is on electoral reforms again. Page 99, para 6.1. The ECI is an independent constitutional body which has been vested with the powers of superintendence, direction and control of the preparation of electoral roll as the conduct of all parliamentary state elections and the elections of the president or the vice president or so and so. 6.3. Article 324(5) of the Constitution intended to ensure the independence of ECI and free from external political interference, and thus expressly provided for the removal of CEC. Removal is like the Supreme Court judges, my lord. Now the appointment part is, my lord, the recommendation, lordship may kindly come to, my lord, page 101. Recommendation, para B, appointment of election commissioner and CEC. Appointment process, the first it has been quoted. And now the final recommendation is page 103, para 6.12.1. Recommendation of the Law Commission. Given the importance of maintaining the neutrality of ECI and to shield CEC and election commissioner from executive interference, it is imperative that the appointment of election commissioner be a consultative process. To this end, Commission adopts
12.2.
Yes, my lord.
The recommendation is
to
that
12.2.
CJI should
Yes.
one of
To this end,
Yes.
the Commission adopts the Goswami Committee with certain modifications. First, the appointment of all election commissioners, including CEC, should be made by the President in consultation with the three-member collegium or selection committee consisting of Prime Minister, Leader of Opposition and Chief Justice of India. The committee considers the inclusion of the Prime Minister as important as representative of the current government. So, my lord, this is, and then lordship would kindly find, my lord. So, my lord, lordship would see, my lord, before the making of the constitution by the various committees, during the debates and post the constitution, my lord, various committees from time to time have recommended that, my lord, it has to be multi-member committee, so it cannot be at the wishes of a single person, single individual, as the Act has provided. Now, in this light, my lord, the Constitution Bench in the Anup Barnwal case had dealt with the aspect at a great length, my lord. Would you now, lordship, take it up, my lord, the volume 3. Page 93 of this, because first I have given the two other judgments, Mohinder Singh Gill and T.N. Session. Page 93. Is, my lord, Anup Barnwal judgment by a Constitution Bench. Opinion delivered by Honorable Justice Joseph, and there is a concurring opinion by Justice Astogi. The judgment starts at page, my lord, 93. 93. The 144 starts at page 144. And 147, so just submissions of Mr. Gopal Singh Karnan are noted, my lord. And para 38 are this, lord, which I have read to your lordship, lord. The historical perspective of the committees and the Constituent Assembly debates are there. And para 84 to 86 is important, my lord. Lordship would permit me to read that. Page 183. Iska page is not para 84. It is clear that founding fathers intended that the elections in the country must be under superintendence, direction and control of an independent body. The body is Election Commission of India. Under Article 324, the Constitution, the Chief Election Commissioner is an unalterable feature or figure. A commission can consist of only Chief Election Commission. A multi-member commission was also contemplated by the founding fathers. However, the post of election commissioner was need-based. For nearly 4 decades, there was no election commissioner. As we have noted that on 1989, first 2 election commissioners were appointed. In that regard, the appointment of the chief election commissioner and the election commission, the constitution does not provide any criteria. It does not fix any classification. It does not prescribe any disqualification in the matter of appointment, either as chief election commissioner or election commissioner. The appointees have been bureaucrats drawn from civil services. 324(5) deals with conditions of service. Then para 86. The first proviso to Article 324(5) acts as a guarantee against the removal of the chief election commissioner, except on like ground, a similar manner, a judge of the Supreme Court can be removed. The conditions of service of election commissioners shall not be varied to his disadvantage. This means Parliament cannot, or the government by rules, either remove chief election commissioner except by impeachment in the manner provided for removal of a judge of the Supreme Court, nor the Parliament can make law, nor the government or rule vary conditions of service of chief election commissioner. The proviso to Article 325 operates as a singular insulation to protect the chief election commissioner either from being arbitrarily removed or his conditions of service being varied to it. But as contemplated by the founding fathers, the protection against arbitrary removal or protection against varying conditions of his appointment were not sole safeguard so far as far more vital was the appointment of the right man and the need to take out of the exclusive hands of the executive. But this is what the ratio of the judgment is, my lord. I'm just submitting. And now, Lord, may kindly come to para 106, my lord, which is page 196. It deals with the cases regarding separation of power and judicial activism. And at para 111, page 197, separation of power has been held to be a basic structure of the Constitution. Page 111, Indira Nehru Gandhi is quoted, the principle of separation of power is not a magic formula for keeping the three organs. 112 is important, my lord. Separation of power is understood as prevailing in India, constitutes a part of the basic structure of the Constitution of India, see Keswanan Bharti. Then Indian Aluminium, adjudication of the rights of the party is essential judicial function. Now, my lord, I will show to your lordship, my lord, the election commission exercise varied judicial powers also, my lord. So it has to be an independent person completely. And the appointment process has to be independent. The adjudication of rights of the parties is essential judicial function. The legislature has to lay down the norms and conduct of the rules which will govern the parties, and transactions require the court to give effect. Now, Roman 4, subpara 4 of para 56, courts in their concern and endeavor to preserve judicial power equally must be guarded to maintain the delicate balance devised by the Constitution between three sovereign organs functionaries, in order that they know that the rule of law permits to fulfill the constitutional obligations of establishing an egalitarian society, respective sovereign functions, etc., etc. Lord, may skip over that part, my lord. Lord, may kindly come to page 198, para 116. Separation of power is a part of basic structure of the Constitution. Equally, judicial review has been recognized as a form of part of basic structure. Judicial review of a legislation is expressly provided in Article 13. A court, when it declares a law by legislation unconstitutional, if it be that it is within its bound, cannot be accused of transgressing the principle of separation of power. Declaration of a law made by the Parliament as unconstitutional form part of its power. In view of the enunciation of the doctrine of basic structure in India, unlike perhaps in most countries, even an enactment to the Constitution can be declared as unconstitutional by the court. Such exercise cannot expose the court to the charge that it is not observing the limits of the Constitution. Then Lord may skip over regarding judicial review. Lord may kindly come to para 186, my lord. Page 224. Para 186. What, my lord, what is important is that the court noted in Anukul that holding free and fair election constitute a basic feature of the constitution and approved of the view apparently that the right to elect is fundamental to the democracy. Even a treated as statutory right at any rate cannot be divulged from the or separated from the mandate of 326. The right is of the greatest importance and form the foundation of a free and fair election, which in turn constitutes the right of the people to elect representatives. We would, for the purpose, list the question rest here to process said. The democracy, my lord, Dr. Ambedkar's speech is quoted, my lord. I have read to your lordship that. And lordship may kindly come to para 200, my lord, at page 229. Article 324 is a plenary provision clothing the article Constitution Election Commission with the entire responsibility to hold national and state election and carries with it the necessary power to discharge its functions. However, the Law Commission cannot act against a law framed by the Parliament or state legislature. The power of the Commission is also subject to the norms of fairness and it cannot act arbitrarily. The action cannot be mala fide. Article 324 governs in the matters not covered by legislation. Being a high constitutional functionary, which is expected to function fairly, legally, if he does otherwise, the court can veto the illegal action. See Mohinder Singh Gill. Now, my lord, 201. Election Commission under 324 can postpone election on the basis of the opinion that there exist disturbed conditions by the state in the state or some area of the state, thus making of holding free and fair election not possible. This court followed Mohinder Singh Gill in democracy depends upon the man as much as the constitution. Election Commission is endowed with the power to recognize political party, to decide disputes arising from them. It can also adjudicate controversies or splinter groups within a political party. The right, this is where the judicial power comes, my lord. I'll show to your lordship later. The commission has also been found to have power of issue of symbol order. This site is traced to Article 324. Then, recognizing the magnitude of exercise of control is fair in election, this court declared that in case of conflict of opinion, the opinion between the Election Commission and the government, as education of machinery to deal with the state of law and order, assessment of Election Commission was to prima facie prevail. This court no doubt observed that mutually acceptable conditions so and so. While dealing with the power of the Election Commission to the requisite staff for election duty, disagreeing with the Commission, it could require the service of the employee of the Bank of India. This court declared the Election Commission did not have untrammeled power. The power must be traced to the Constitution. Election Commission has the power to issue directions to conduct elections, requiring the political party to submit details of the expenses incurred or authorized by them for the purpose of election of their respective candidates. The power was traced to the conduct of election. All the powers of election, though not specifically provided, but necessary for effectively holding elections, are available to the Election Commission. So 324 is the reservoir of power. Now, lordship may kindly come to my lord, para 207. From a spate of